Hello, my name is Shaya, and along with my colleagues Jack, Rebecca, and Rafel, we'll be presenting the United Kingdom position on remedies during this course. In order to do so, we will firstly provide with an overview of UK's overall position on progress towards a European contract law, and in doing so, we will present you with the response that the UK gave to the Green Paper of 2010 made by the Commission. Secondly, we will deal with the issue of remedies, what it's about, and why it's important. In the second part of the presentation, we will deal with UK's position in regards to remedies and compare that to Ireland and France in order to get a sense of comparison of how things differ and are similar in these countries. The Green Paper issued by the Commission in 2010 was a set of options of policy opinions that the countries could use in order to develop their own legal system and their own policies in order to progress towards a European contract law in the end. Generally, the UK holds back when it comes to such progress because it believes that there is no reliable evidence at the moment that the current national arrangements hinder the proper functioning of internal market in any way. Out of all the options presented by the Commission in this Green Paper, the UK is only in favor of option 1 and option 2A. Option 1 states that the publication of the results of the expert groups should be used only as an inspiration for member states in order to make their own policy statements, and this should pose no union-level endorsement. Option 2A provides that an act can be drawn up from expert results, and that those should be used as a toolbox for the Commission to improve coherence and the quality of the legislation they're making. So therefore, these two options are rather soft for member states to kind of do their own thing and they won't be bound by anything. Whereas option 4 of this Green Paper provides a regulation which is made for setting up an optional instrument of European contract law within the member states, providing them with a second regime, which would allow them to pick from the two options available to them. The UK is very skeptical of this option and believes that it has no practical effect and it would take a lot of substantial change and substantial integration in order for it to work. Moving on to the issue of remedies. Remedies are options available to the disadvantaged party as a result of a breach of contract of the other party. It covers the issue of performance, damages, and termination. Performance covers the issue of forcing the other party who was obliged to perform in the first place to perform their obligations. Damages are the second option available when the party is not able to actually perform and therefore should compensate the disadvantaged party in monetary ways. And termination is the last resort in which parties who cannot perform and parties who cannot obtain damages can terminate the contract and their contractual obligation all in all. The reason why the position of the English legal system is so important is because English contract law is actually used in international sale of goods in a lot of different occasions. It's often used as the basis, and furthermore, many countries which were formerly colonies of the United Kingdom now retain characteristics and traces of the common law system. Therefore, the solutions provided by the United Kingdom in contractual obligations and remedies is common in a lot of member states.
Hello, so I will be talking now about the United Kingdom and compare it to France when it comes to performance, damages, and also termination. So performance between two business, so B2B, exists in the United Kingdom, however it is only a secondary remedy. The focus lies on monetary compensation, so damages. The Sales of Goods Act states in Article 52 that specific performance is only available for unique or specific goods. So this is the case, for instance, when it's a piece of art or a unique object which cannot be replaced with money. It is very rare, although the courts do have discretion to give performance, they very rarely do it. So obviously it's not in our best interest or in the UK's interest at all to change to the continental system of having performance as the primary remedy, as it simply clashes with our legal tradition and our tendency to go towards compensation. On the other hand, you have France, which is a continental civil law jurisdiction, and as most, or if not all, the continental civil law jurisdictions have, they have the primary remedy as being specific performance. Only where this is not possible can the contract be terminated and damages claimed in France. This is enshrined in Article 1184, as you can see, and the situation in which it would not be possible, for instance, to have specific performance would be if you're trying to sell a ring and the ring falls into a river, for instance. Obviously, then it would be unreasonable to go and try and find the ring in the water. However, when it comes to business to consumer, we have the Consumer Sales Directive, which harmonizes the law between all the member states. The primary remedy is repair or replacement under Article 303. Only where this is not enough will there be a price reduction or recession or termination of the contract, which is a secondary remedy. This may be the case when the repair or the replacement will not be able to cover the cost anymore. So for instance, if you have an event which you're planning and then you ordered a stereo for the music, however the stereo did not turn up in time, then there is no point anymore. Or a wedding dress, there will be no point to get the wedding dress after the wedding. In France and England specifically, you have the Sales of Goods Act, Article 48, A and B, which requires the buyer to choose between replacement or repair, and you have exactly the same in France under CDLC 211.9. So you can see that although it differs from a B2B perspective, it is the same in B2C, as the law has also been harmonized by now. Now coming to damages. Firstly, in the United Kingdom, obviously that's the primary remedy if there is a breach of contract, as we've established already. As you can see here, the nice quote by the Judge Oliver Wendell Holmes: "The law makes the promiser pay damages if the promised event does not come to pass." Therefore, as you can see, this is primarily the case. The only difference is that, or the only case where this is not happening is during frustration. So what does this mean? If it's an unforeseeable case or really an impossibility to perform, here we have the case of the Burn Theatre in Tyler versus Caldwell, where there was the theatre was rented for performance. However, the theatre burned down, so obviously it was impossible to actually fulfill the obligation of enabling them to play in the venue, as the venue simply didn't exist anymore. In the Peanut case, the argumentation was that the trip was simply too long and the damages, or the costs to the firm delivering the peanuts would have been larger than the profit they would have made going around, I believe, the Cape of Africa. However, this was not seen as an impossibility, but rather bad planning by the company. Therefore, this was not seen as frustration, and in this case, it was not an impossibility, and thus the court did not grant frustration. So, to summarize again, primary remedy is damages for the UK. Moving on to France, where it's a secondary remedy, so only where the performance is not possible. As with most, or if not all civil law jurisdictions, there's 5 criteria which usually have to be met. So this is non-performance, so breach of contract, damages, causation, so direct link between the damages and the breach of contract. Sometimes, not always, a notice, or most of the cases, but not always, a notice has to be given, especially if there's a specific time specified in the contract for the performance. Lastly, it has to be attributable, so it has to be there can't be an excuse. What does this mean? In France, mostly it's because of force majeure, or as the Americans would say, act of God, which simply means that it's, as well as in England, similar to frustration, unforeseeable, and simply can't be attributed to the individual. So if there is a thunderstorm and lightning hits your house and burns it to the ground before you were actually able to move in after you bought it, or before you received it, even though you paid already, then this can't be attributed to the real estate agent because simply he didn't do it. This summarizes damages. Again, secondary remedy in France, and in our jurisdiction or in our legal system, the UK, it's the primary remedy. So, the last point will be termination, first in a B2B context, so business to business, and then in a B2C, so business to consumer. Starting off with the United Kingdom, there must be a breach of condition of the contract. So what does this mean? It has to be a fundamental point or essence of the contract. It has to be something which the contract without it would make no longer sense. So for instance, the quality of the product, the purpose of the contract, the purpose of the product, etc. And this is also stipulated in Article 12 to 15 of the Sales of Goods Act. What could be a fundamental part of the contract, which if there is a breach of it, there would no longer be a sense to keep the contract? For instance, the timing. As the earlier example was mentioned with the wedding dress, if the wedding is on the 15th and it's delivered on the 20th, then there is absolutely no point to it anymore. So yes. If you look at France, it is very similar, if not the same. There must be a resolutory condition which is breached. These are implied in every bilateral contract, which would also mean the same kind of principles as the UK. So if the timing is off, which is specified, or the product is simply unusable. So it really has to be a fundamental condition which was breached. What's a bit different is that they must apply for it in court in order to get the termination. However, in practice, often simply another clause or another contract for termination is added or is established. Looking now at B2C, so business to consumer, again the directive comes into play, the directive on consumer sales, which first of all in 3.3, as we established earlier, the primary remedy is repair or replace. However, when this is no longer enough, a price reduction or termination can be a secondary remedy or can be the valid remedy. This would mean that it has to be either because the consumer is not entitled to R&R, so repair and replace, or there was a failure to repair and replace in a reasonable time period. Again, coming back to the example of the wedding dress, for instance. Or, for instance, the seller cannot remedy problem without significant inconvenience to the consumer. So if actually repairing or replacing the product would inconvenience the consumer to a larger extent than just terminating the contract, then of course this is no longer reasonable and you can terminate under 305. Again, we can see here how the law has been somewhat harmonized due to the directive. This brings to an end the comparison between the United Kingdom and France, and now it will be moving on to Rebecca's part. Now going on to Scotland, the system is a mixed legal system, which is a mix obviously between the civil and common law. This differs from the purely common law English system or the civil continental system such as Germany or France. This has an impact on the remedies in contractual law, as can be seen by the fact that Scottish people have the option to claim performance, as is the case in the civil law. The preferred option is not damages, as is the case in English law, but rather you really have the option to choose. Through case law, it has developed that the preferred option was actually performance, This can be seen by the cases of White and Carter Limited and also Highland and Universal Properties. In that sense, damages is rather a follow-up option to performance. However, it has to be again reiterated that there is the option to choose between the two. This is of course not the case in Germany, where the primary remedy is performance, as was also the case in France and in most, if not all, civil law countries. So in a business-to-business situation, the primary remedy will be performance, whereas in Scotland you have the choice. When it comes to B2C, so business to consumer, there is the Consumer Sales Directive, as was already shown earlier with France and England, which is in Article 3 that there is the repair or replace option, or rather remedy, as the primary remedy. Only where performance is no longer possible or in unforeseen circumstances can there no longer be performance, and then damages can be claimed. This differs to the UK with the frustration doctrine, which is far more strict in a sense than Germany. Furthermore, for claim of damages, Germany requires a Nachfrist for damages, which basically means that it is a notification after the period of performance is up to give a second chance to perform, which of course greatly differs to the UK, which straight away goes to damages, and also differs from Scotland, where you have the option between the two, and where the Nachfrist requirement does not exist. Moreover, rather than being a fundamental part of the contract which has been breached, it simply has to be a serious or not trivial. The Consumer Sales Directive, of course, states that the repair or replace has to be in a reasonable time, and it cannot place a significant inconvenience on the consumer. Otherwise, damages can be claimed. Now, this is the same for Scotland because it's a directive. Therefore, it applies in both Scotland, England, France, and of course also in Germany. This brings us to the end of this presentation and our introduction to the United Kingdom. And in summary, again, the United Kingdom, the preferred remedy and the primary remedy is damages, in contrast to performance, as is the case in continental systems.